Direct exam is the heart and soul of your case, regardless if you're prosecution, plaintiff, or defense. Direct examination is your opportunity to tell your story through your witnesses, and good stories win trials, period. In this video, I'm going to give you a few tips and tricks to help you conduct a better direct exam. Coming up. Hey, what's up everybody? I'm attorney Eric Scramlin and this is Law Venture. And if you're tired of all those boring CLEs with the death by PowerPoint where you can't figure out what's going on, hit that subscribe button down there. On this channel, Jarrett and I give you the high value takeaways, cut out all the boring stuff to help you become a better lawyer. In this video, I'm going to be giving you a fact pattern of a case that I actually tried to a jury as a prosecutor a few years ago. I'm going to go through step by step. We're going to cover some tips and tricks on how I drafted a direct examination for one of the key witnesses in that case. So let's dive right in. Step one is preparation. And listen guys, I know, I've been there. You're going to be crunched for time and you're going to want to jump ahead and just start writing out those questions. Resist the urge. Preparation is so important to how the direct examination is going to come out later, so don't skip this step. Before I give you guys the fact pattern, I want you to write these 3 questions down because this is what you're going to be asking yourself as we go through the fact pattern. Number 1, what is the story that I'm going to tell to the jury based on these facts? Number 2, what role will my direct exam play in that story? And finally, number 3, what are the favorable and unfavorable facts that this is going to add to or take away from that story? In this fact pattern, I'm going to be playing the role of the prosecutor. But if you're a defense attorney, the same rules apply, just fill in the blanks as you go along. Defendant, we'll call him Murray, is charged with aggravated assault with a deadly weapon. The criminal complaint alleges that the victim, Erica, was driving down a shared easement with the defendant, Murray. Murray was raking some leaves, sitting in his truck bed at the edge of his property near the road when Erica drove by. Murray pointed what Erica described to be a small rifle at her. While pointing the rifle, Erica told police that Murray was shaking his fists and yelling something about garbage in his yard. In Erica's statement to police, she told the police that she has a contentious relationship with Murray because they share the easement and a property boundary line, and Murray has been upset and accusing her of letting garbage blow into his property. It's also important to note that Erica tells police that she's not familiar with firearms at all, but she was terrified for her life when she saw what appeared to be a rifle being pointed at her. So let's go back to those questions I had you write down. Number 1, what story is my case going to tell to the jury? Remember, good stories win trials. Confusing messages with no clear calls to action lose, period. So the key here is let's focus on the facts to figure out what is our story going to be, what is our theme and theory going to be that we are going to present to the jury. In order to create that message, that call of action to the jury to find guilt in my case, I've developed a theme and a theory. My theme is that this is a case about a defendant that's about to snap. My theory is that the defendant took a gun, pointed it at my victim because of an escalating property dispute brought on by the defendant's own conduct. Now that I have a theme and a theory, it's time to move to question number 2. What role will this direct examination play in telling my story to the jury? So if you look at the example that I gave you, if I'm doing a direct examination of the victim in this case, as the prosecutor, I need to look at what role my victim's testimony is going to play in telling that story. Now, if you're the defense attorney, you're also going to be poking holes and weaving your story into your direct examinations. But as the prosecutor, I have the burden of proof. And direct examination is my only shot at proving the evidence without the judge giving me a directed verdict. So I'm also going to have to weave in and focus on those elements that I need to prove beyond a reasonable doubt. So in my case, if I'm doing a direct examination of Erica, my victim, I want to focus on the story that I've developed in my theme and theory. So I want to elicit that background from Erica about the property dispute, what her actions are versus what the defendant's actions have been over time. And I also have to weave in there those things that we have to prove, like identifying the defendant, establishing jurisdiction and venue if I can, and talking about that gun. That's going to be an issue because admittedly, and I'll get to this in a minute, Erica's not well versed in firearms, so I need to be able to establish that through the facts of my direct examination. Question number 3, what are the favorable and unfavorable facts of each witness? This is where the rubber meets the road. This is where we're going to start writing down some things that are going to translate into our direct. So I want you to grab a legal pad, a piece of paper, or if you use your laptop, just find a way to separate your favorable and unfavorable facts on your Word document. I want you to draw a line right down the middle of your piece of paper. And on the left-hand side, I want you to write favorable facts. And on the right-hand side, you're going to write bad facts or unfavorable facts. Don't skip this step. You must review the evidence, any statements from the witness, body cams, photographs, statements from other witnesses that might bear on the witness's testimony you're doing the direct for here. It's key that you figure out what facts are favorable to your story so you can focus on bringing those points to life. It's also just as important to identify any damaging evidence that might be elicited from this witness so you can formulate a plan to deal with it. I call this drawing the sting, and I'm going to talk more about that in just a second. So let's take a look at some of the things that I've identified as favorable and unfavorable when it comes to the direct examination of my witness, Erica. 1, she can ID the defendant. That's going to be huge. That's one of the elements I need to prove. The fact that she was scared for her life when the gun was pointed at her. And I'm also going to focus on the fact that she saw the gun swinging towards her and then pointing at her. I also think she's going to make for a sympathetic victim based on her story. A couple of things that I've identified as unfavorable is that the defense may be able to point to some sort of motive based on the neighbor dispute. Also, I've kind of looking at the idea that she doesn't know a lot about guns, and this could be an issue if the defense is going to make that argument that, hey, this wasn't a deadly weapon, this person doesn't know anything about guns, maybe he was pointing a BB gun or a stick or something like that. At any rate, that could be an unfavorable fact for me. So as you can see, most of the work is done in the preparation phase. Once you've identified your favorable and unfavorable facts, you've figured out what role your direct is going to play in telling this story, you're essentially ready to write the questions out. Now it's time to just simply put it down on paper and organize it. Your direct examination can typically be organized in one of two ways: topographical or chronological. Let's start with chronological organization because that's typically the simplest thing to do. Essentially, all you're doing is starting at the beginning and then walking your witness through the events in a timeline fashion till the end of the direct. Topographical organization, as the name implies, is simply organizing your direct by topic. So you may start off with an introduction, tell the jury about your witness, then you may jump right in to the events and how she saw the gun being pointed at her. Then you may want to jump ahead to speaking with the police and then go to another topic and another topic. The idea here is you're organizing these topics in a way that fits your story and that you feel is the best way to get this information in front of the jury. One of the things I like to point out is that jurors and humans in general, we learn by primacy and recency. So whatever we learn at the beginning and whatever we learn at the end is typically those things that are going to stand out. Ultimately, choose a method that works for you. Whatever you're going to be comfortable with and whatever you think is going to tell that story to the jury in the most effective way is the method that you're going to want to go with. Step 3, it's finally time to get those ideas and put them down on paper and write out the direct exam. So let me go over a couple of tips and tricks on how to actually write those questions and how to pull that information out of your witness. Tip number 1 is to simply remember to just follow the rules. Your direct and your story is going to get derailed quickly if you're asking leading questions or you're asking a lot of questions that are drawing objections from opposing counsel. Tip number 2 is to craft those questions in a way that keeps your witness focused. You don't want to ask vague questions such as, what were you doing that day? Instead, you want to point the witness in a particular direction, like, when you were standing next to your car, where was the defendant? Now, it might be difficult to be able to point your witness in the direction you want them to go and avoid getting those leading question objections. So a technique that works really well in this area is a technique called looping. Now, looping not only is going to work for pointing your witness in the direction you want them to go, but it also reiterates important information and helps get that important stuff back in front of the jury. Some examples of that technique would include something like this. You testified that you lived at 3302 Lake Road your whole life. Were you home on October 24, 2019? Did you come into contact with the defendant that day? Okay, when you came into contact with the defendant, was that at your house or on the road that leads to your house? Were you coming from your house or were you coming from the main road when you saw the defendant on the road that leads to your house? Okay, as you turned onto your road from the main road, where was the defendant at? As the gun was pointing at you, how did you feel? Questions like this can help point the witness in a very specific direction, and we're also reiterating those important points and getting those back in front of the jury. Don't forget about those unfavorable facts that we wrote on the other side of the paper. We need to deal with those. We call this technique drawing the sting. Now, at the very least, we're going to bring out those negative facts so we can take away from opposing counsel's ability to have that aha moment when they get in front of the jury and say, gotcha. So we want to take that away and kind of draw that away by at least highlighting those. But if we're really effective, we want to see if we can find a way to use what seems to be an advantage for opposing counsel. We want to use that against them. Nowhere have I seen this done more effectively than the movie 8 Mile, when Eminem is in the final rap battle scene.
Here, tell these people something they don't know about me.
This is what you want to try to do with drawing the sting. You want to find a way, at the very least, to draw out the impact that those negative facts are going to have when your opponent brings those out in cross-exam. But if you can find a way, you want to see if you can turn it and use it to your advantage. The final step in the process is to be sure that you end the direct examination strongly. You want to hit on a point that leaves the jury with something that really resonates with your call to action. What I generally tend to do, especially with the victim, in this case if we had Erica on the stand, is I would ask her a question such as, how has this event made you feel? How has your life been different? You know, something that's going to give that human touch in front of the jury and be able to add to our story. Now, you have to be careful here because depending on your judge, you may or may not be able to go that far. You may draw an objection, right? And you never want to end on an objection. So make sure you always have a backup ready. All right, let's do a quick recap. Remember, don't skip the preparation phase. Take your time to go through and look at the witness statements, the body cams, the criminal complaint, all the evidence. Develop your story. Develop a theme and a theory, and make sure you go through each witness and write those favorable and unfavorable facts. By the time you take pen to paper, you should already have your direct examination questions essentially written. You just have to put them down on the paper. Click on the cross-examination video up there on the screen if you want to learn about the next step in the process, and make sure you hit the subscribe button so you can have access to all of Law Ventures trial advocacy videos. I'll see you guys next time.